Enough time on this bench teaches you that some cases arrive looking routine until the first human being opens their mouth. On paper, Ava Mercer's file contained nothing remarkable. Parking citations, towing charges, storage fees, missed hearing penalties, and an assault notation claiming she had spat at the bench during a prior appearance. $12,460 in total. Then she walked into my courtroom, and everything that paper believed it knew began coming apart. Rain was striking the courthouse windows before sunrise that morning. First with the lightness of fingertips, then with enough force to sound like knuckles. I was already in my robe, holding a file thick enough to bend. After all the years I have occupied this bench, I can feel when something is wrong before anyone has spoken. Some mornings the room goes quiet long before the people do. That morning was one of them. The courtroom carried the smell of wet wool, old wood, and burnt coffee from the clerk's desk. The light was a tired gray that made every face in the room appear worn out before a single word had been said. The city wanted money. That is always where it begins. Numbers, balances, penalties. 3 unpaid parking citations, an impound fee accumulating by the day, 2 missed appearances, 1 incident described in the record as serious enough to justify an assault notation. Then at the bottom, the line inserted to make everyone stop asking questions. Assault on the bench. The city was not simply pursuing unpaid fees from Ava Mercer. It was attempting to transform her into a threat. I looked at the surname before I looked at the amount. Mercer. The same as the police chief, Daniel Mercer. A man whose name reached rooms before he did. Word had already moved through the hallway before I took my seat. The chief's daughter was coming in. Half the room was expecting arrogance. The other half was expecting favors being quietly extended. I expected neither. I expected a person. That is the only way I have ever been able to do this work and still sleep at night. Then the side door opened, and Ava Mercer stepped into my courtroom. Every pair of eyes in that room shifted at once. You could feel it happen the way you feel a change in pressure. She wore a faded green coat that had lost a button near the collar. Beneath it was a diner shirt washed so many times the fabric had nearly surrendered. Her jeans were clean but worn thin at both knees. One shoelace was bright white and clearly recent. The other was old, flattened, and gray. People who are barely keeping life assembled always end up wearing repairs alongside wear. I noticed those things. A judge who cannot read the details of what is standing in front of her has no business being one. Her hands told me more than her clothing did. Red knuckles, skin roughened by soap and winter air, a pale burn mark near the right thumb of the kind people in commercial kitchens accumulate when they are working too fast because they cannot afford to slow down. Her nails were cut short, with fragments of old black polish still clinging to the edges. Not a fashion choice. Just the ghost of a better week. She kept those hands pressed together too tightly, as though releasing them might allow them to shake. Her lower lip was split at one corner, crusted dark where it had dried, and a strand of hair kept slipping from her ponytail and sticking against her cheek. She never pushed it away. That told me her mind was already somewhere beyond vanity and somewhere considerably harder. Mr. Colin Reese stood for the city. He was neat in the way some people wear neatness as a form of armor. Blue tie, silver watch, files arranged on the counsel table with such precision you could have measured their alignment with a ruler. He was not cruel, and I will say that directly, but he placed his confidence in records rather than in people, and the records had already told him who Ava Mercer was supposed to be. He began with the numbers because people of his disposition always do. 3 parking citations left unpaid, an impound fee growing by the day, 2 missed appearances, 1 incident the city had decided was serious enough to warrant an assault notation. He asked me to uphold every dollar and every label. His voice stayed level and cool throughout, which somehow only made it feel colder. I looked at Ava and spoke as carefully as I could. "Ms. Mercer," I said, "I have read the papers. Now I need your life in your own words." She lifted her chin, but not with pride. It looked more like effort, the kind that taxes the neck because you have been carrying too much weight for too long. When she answered, Her voice came out dry and scraped down to its surface. She said she had not lived with her father in nearly 3 years. That got everyone's attention, though no one produced a sound. She rented one room in a motor lodge near the highway when she had the money for it. When she did not, she slept in her car behind the diner where she worked the night shift. The car the city had towed was not a backup form of transportation. It was shelter on the difficult weeks. I asked why she had missed the first hearing. She swallowed once before answering. Her mother had kidney failure. That meant her mother's kidneys had stopped clearing the waste from her blood. Ava had been transporting her to treatment before dawn and then working the breakfast shift afterward. The first court date landed on a morning when her mother could not breathe correctly, so Ava chose the hospital. The record said absent. Life said daughter. Mr. Reese looked down and turned a page. He said that illness did not dissolve city fees. He was not wrong in the narrowest technical sense. Rules must reach everyone or they carry no meaning. But a small truth can conceal a larger one. That is precisely where systems collapse. They reach for the nearest point of technical correctness and name it justice, because doing the deeper work requires something institutional structures rarely develop: imagination. So I asked Ava about the tow. Her eyes moved toward the back benches for a moment, then returned to me. She said the car had been tagged outside the dialysis center. An officer ran the plate, saw the last name, and asked if Chief Mercer was her father. When she confirmed it, he laughed once and told her she could obviously afford the fees. Then he called the tow truck anyway. Her mother's blanket was in the back seat. So was her younger sister Lily's inhaler, her school shoes, and a grocery bag containing frozen peas. Ava asked for 10 minutes to retrieve the inhaler. She showed the officers a school photo of Lily on her phone. Nobody allowed her to touch the car. By that point, I believe everyone in that room was asking the same silent question. If a young woman carries a powerful man's last name but none of his protection, what exactly does that name buy her? Respect, or simply a different and more particular variety of humiliation? Then I asked why she had missed the second hearing. She stared at the front of my bench for long enough that I thought she might not answer at all. Then she said her mother had died at 4:12 that morning. She said it quietly, in the way people recite facts they have repeated often enough to carry them through the hours of the day. She had come to court directly from the funeral home because she was terrified of missing again. She was still wearing the same shirt she had signed paperwork in. When people hear the word breakdown, they tend to imagine noise, shouting, movement, disorder. Most genuine breakdowns begin with stillness. Ava went very still. Mr. Reese asked whether grief absolved threatening behavior in a courtroom. She attempted to respond, but her mouth caught on the words. Then she pressed 2 fingers to her split lip. When she pulled them away, there was fresh red on her fingertips. She said one more thing before the room broke open. She said her father had not come to the hospital. He had not come to the funeral home. He had sent a patrol sergeant carrying flowers and a printed card. Then she laughed once, but it contained nothing that belonged in laughter. It sounded like glass breaking inside a locked room. She lifted her face toward me, trying to push air through blood and something that had gone beyond grief. And a thin spray of red struck the rail below my bench. Everything that followed happened in under 30 seconds. A chair scraped the floor. A bailiff moved forward. Someone shouted that she had spat at the judge. Ava's wrists were pulled behind her so quickly that her shoulder struck the edge of the table. Mr. Reese stepped back. The clerk froze with her hand over her mouth. By the time I stood, the handcuffs were already on. I raised my hand and said, "Take those cuffs off." No one moved. I said it again, more slowly. "Take them off." My bailiff looked at me, then at the red on the rail. "Judge," he said, "she spat at you." I looked down at the rail. Most of what I could see was blood. Mr. Reese started to object. He said the bench had been struck. He said the officers had acted to protect the room. He said intent could be inferred. What he meant was that he wanted me to assume motive from contact and disregard the person standing in front of me. I told him that assumptions have no business in a room where facts are available. Then I asked for the hallway camera footage, the bench camera footage, and the intake photograph taken at the time of booking. While the clerk retrieved the footage, I asked Ava 3 questions. Did anyone offer you water this morning? No, Your Honor. Did anyone ask whether you needed medical attention? No. Did anyone document your split lip before the incident in this room? No, again. That silence reached further than any argument could have. A room full of adults arrived at the same understanding in the same moment. A young woman had been moving through public systems with a visible injury, and no one had slowed down long enough to see a person before they documented a problem. The first video appeared on the monitor above the jury box. No audio, only a timestamp in the corner. There was Ava at the metal detector, shoulders drawn in, arms wrapped around herself. She touched her mouth, bent forward once, then raised one finger, small and careful, requesting a moment. No one came. The second angle showed her inside my courtroom from the side. Mr. Reese was speaking. Ava pressed a napkin against her lip. When he referenced threatening behavior, she flinched before he had even finished the sentence. Then she attempted to respond. Her body folded on the first word. She coughed blood and turned her head downward as she did it. The spray reached the rail. It did not reach me. Not once. Then the intake photograph appeared on the screen. It had been taken 3 minutes after the handcuffs were applied. Ava's lower lip was split wider than before. A front tooth had cut through the flesh from the inside. There was blood on her sleeve where she had tried to cover her mouth. The booking officer had noted visible injury. That notation had never appeared anywhere in the city's summary. I turned to Mr. Reese and asked him why. Why had the injury been omitted? Why did the summary describe her as having spat at the judge when the footage showed blood from a fresh cut? Why had no one recorded her request for a pause in the hallway? Why had a grieving young woman been processed as a threat before anyone thought to process her as a person? His jaw tightened. For the first time that morning, he had no prepared answer ready. Eventually, he said that courtrooms depend on order. He said officers cannot wait to establish motive in the middle of a live disturbance. He said the rules are designed to protect everyone in the room, including me. He was correct about the necessity of order. I told him so. Then I told him that order without judgment is simply speed, and speed is often how injustice gets dressed and escorted out the door before anyone notices it has happened. The law is a tool, I said, and a tool is only as honest as the hand that uses it. If a hammer strikes the wrong board, we do not commend the hammer. We correct the aim. This young woman brought debt and grief and a mouthful of blood into my courtroom. The system looked at the result and named it danger. That was not discipline. That was cowardice, wearing a badge and carrying a clipboard. The room went so quiet I could hear the heating vent. Ava stood there with her hands now free, though she still held them close to her body, as though she had not yet registered that the cuffs were gone. Mr. Reese lowered his eyes to the table. He made one final attempt. He said that if this court softened here, others might conclude that distress erases rules. I told him that distress erases nothing. Truth changes everything. Then I picked up my gavel. People believe a ruling begins with the strike. It does not. It begins in the breath that precedes it, in the moment when the room understands that something final is about to become real. I looked at Ava Mercer, then at the city's table, then at the stain on the rail, and I spoke one sentence at a time. The assault charge is dismissed. The emergency arrest in this courtroom is vacated. All fees tied to the impound period during her mother's final treatment are removed. The missed appearance fees are removed. The storage charges beyond the first day are removed. The remaining parking debt is reduced to an amount this court considers both real and payable, $120. No interest, no stacked penalties. Ava did not cry in the way people anticipate. She blinked once, hard, and then her jaw loosened the way a knot loosens when someone finally releases it. Her fingers found the edge of the table, not to grip it, but almost to confirm that the wood was real. Her shoulders dropped by approximately 1 inch. That single inch communicated more than any outburst could have. She attempted to speak, but no sound came, so she nodded instead. Slow, careful, and formal. The kind of nod a person produces when simple fairness has become almost too much to receive. Then I did something I believe judges should do more often than they do. I asked the clerk to bring water, not for the room, for Ava. When the paper cup reached her hands, she wrapped both of them around it as though it carried warmth. I asked whether Lily had an inhaler now. She whispered yes. A nurse from the clinic had delivered one to the motel the previous night. Then I reached into the side drawer of my bench and removed a plain card from the court's family support office with one name written on the back: Denise. I told Ava that Denise helped people locate emergency housing, grief counseling, and school support for children. I told her to call that day, not later, not once things had gotten worse. Sometimes dignity begins with knowing where to knock. That was when a voice came from the back bench. Rosa Flores, the manager of the diner by the bus depot. I recognized her face before I knew her name. She asked if she could speak. I gave her permission. She said Ava had worked double shifts for months without complaint. She said this young woman packed leftover toast for her sister before school, kept a spelling list in her apron pocket, and quizzed Lily on vocabulary between clearing tables. Then Rosa looked directly at the city's table and delivered the line that room had been waiting to hear. This child is not living off a badge, she said. She is surviving in spite of one. That landed precisely where it needed to. 2 weeks later, the full video became public. Not a rumor, not a partial clip. The complete footage. The hallway request for a pause, the blood on the napkin, the turn of her head, the rail receiving what came forward. By noon, every local station had it. By evening, the story had moved well beyond the county line. Letters began arriving at the clerk's office, grocery cards, small personal checks, apartment leads. A retired dentist offered to repair Ava's broken tooth at no charge. A landlord waived the security deposit on a small apartment near Lily's school. Church groups sent gift cards. The diner where she worked placed a collection jar near the register. A mechanic repaired the old car for the cost of parts only. A funeral home returned half the service fee. Within 2 weeks, more than $4,000 in assistance had arrived. Not enough to dissolve grief, enough to change a month. Sometimes that is the distance between collapse and continuation. 6 months later, Ava came back, not as a defendant. She sat in the back row until the calendar had ended. She wore a navy coat with both buttons intact. Her shoes matched each other. Her hair was smoothed and tucked behind both ears. The scar on her lip remained, but no longer looked as though it had been left there alone. Lily sat beside her in a yellow cardigan holding a library book with the pride of someone displaying a trophy. When I asked how school was going, Lily informed me that she had read 12 books that month and produced her inhaler from her backpack pocket with visible satisfaction. Ava told me she had moved into a 2-room apartment above a florist. Rosa had helped her transition to more day shifts. Denise had arranged grief counseling and after-school care for Lily. The dentist had repaired her tooth. A local community fund had covered 1 semester of night classes. She was studying medical billing because, she said, the word stable sounded beautiful to her. I understood exactly what she meant. Then she retrieved a folded piece of paper from her bag. It was Lily's spelling test, every word correct. At the top, in unsteady pencil, Lily had written, "Ava, help me." That paper was worth more than half the evidence I process in a given month. The letters continued arriving for weeks after the story spread. Some were written in the careful block print of people who did not entirely trust themselves with too many words. A grandmother in New Haven sent $20 and wrote that her own daughter had once stood in traffic court, shaking too hard to hold a pen, and that no one had looked twice. A high school civics class from Hartford sent a card signed by 31 students after their teacher showed them the footage and asked what public service was supposed to mean. A nurse from the dialysis center sent a note explaining that she remembered Ava and her mother by name, that the mother always apologized for being trouble, and that Ava had not left the chair beside her once, even when her phone kept lighting up with messages from the diner. The clerk's office stacked those envelopes in a tray beside the printer until the tray could hold no more. One morning, my clerk asked whether I wanted any of them forwarded to Ava personally. I said yes. But first I read through them, because what a community chooses to respond to tells you something important about what it is starving to witness. What those letters said, written in different handwriting across different distances, was that people recognized themselves in her, not in the chief's daughter, not in the headline, in the daughter who had missed court because she was fully occupied being a daughter, in the sister carrying a child's inhaler, in the person working to keep a roof over two people and a dying mother warm. The public understood with perfect instinct what the system had failed to see in the paperwork. She was not manipulating anything. She was drowning and still trying to row. The city issued a statement. There was regret expressed over the misunderstanding, a commitment to reviewing procedures, and the familiar promise to balance compassion with enforcement. I have read enough statements of that kind to understand what they are designed to accomplish. Sand down the edges. Substitute atmosphere for accountability. I sent word back through the administrative office that I had no interest in atmosphere. I wanted the revised intake checklist, the body camera guidance, and written instruction requiring visible injuries to be formally documented before any escalation could proceed. If people are going to bring damaged facts into my courtroom for correction, then I expect the offices supplying those facts to absorb the lesson. I thought about Chief Mercer as well, though not with warmth. Public power produces many varieties of failure, but among the ugliest is the kind that allows a child to carry your name while receiving none of your shelter. He never appeared before me in connection with that matter. There was no apology entered into the record. Perhaps that disappointed people following the story from outside. It did not disappoint me. I did not require his face to understand the shape of his absence. Ava had already described it more convincingly than any cross-examination could have produced. Months after the ruling, Denise from the support office stopped by my chambers with an update. Lily's school attendance had improved substantially. The counselor there believed the child was finally becoming settled enough to learn without scanning every room for the next source of disruption. Ava had not missed a single night class. She still worked more than anyone her age should carry, still held more than should reasonably belong to one person, but she had stopped prefacing every request with an apology. Some people spend years operating under the conviction that their own needs constitute an offense. The first sign that something is healing is often not happiness. It is the disappearance of unnecessary apology. There is a reason that matters to me. The years I spent in family court showed me that suffering reorganizes language long before it reorganizes circumstance. Women begin each sentence with, "I am sorry." Children say it is okay when it clearly is not. Men describe genuine collapse as a rough patch because using the accurate word feels like it might bring the entire structure down. Part of a judge's work, done honestly, is listening for the lies that pain teaches people to tell about themselves and then refusing to confirm those lies as true. People imagine the law as a hammer. On certain days, it is. But hammers are crude instruments. The better image is a scale, and scales only function when someone examines what has been placed on each side. On one side of Ava's case sat citations, fees, missed appearances, and a red mark on a wooden rail. On the other sat a mother's death, a child's inhaler, an impounded car that was also a home, a split lip, a motel room, a diner shift, a sister with a spelling list, and a city moving too quickly to distinguish blood from threat before calling in the charge. My duty was not to admire the paperwork. It was to weigh what was true. And if that story stayed with people beyond the day it happened, I believe it is because people are profoundly hungry to see that kind of weighing occur somewhere they can observe it. They know what it feels like to be summarized by an institution that never looked up from the form. They know what it is to have one difficult morning transformed into a permanent category. So when a courtroom slows down long enough to say, no, we are going to look at this again, the relief it generates is larger than any single case can account for. It becomes a form of civic memory. I have sent people to jail and I have sent people home. Both carry weight. But if you occupy this work for a sufficient length of time, You learn that the law cannot restore what it refuses to recognize. A human being is never the worst second of the worst day she has lived through, not if we take the time to look again. That is what remained with me after Ava Mercer left my courtroom. Not the mark on the rail, not the headlines, not even the sound of the gavel. What remained was simpler than any of those things. A grieving daughter arrived expecting to be destroyed, and for once the room chose not to destroy her. That is where justice begins.